441 G Street, NW, Washington, DC 20548 B 333,857 April 18, 2022 The President The White House subject, violation of the time limit imposed by the Federal Vacancies Reform Act of 1998, Administrator, Office of Information and Regulatory Affairs Dear Mr. President, pursuant to Section 3349, B, of Title V of the United States Code, we are reporting a violation of the Federal Vacancies Reform Act of 1998, Vacancies Act, 1 at the Office of Information and Regulatory Affairs, WERA, Office of Management and Budget, OMB, with respect to the administrator position. Specifically, we are reporting that the service of Dr. Dominic J. Mancini as acting administrator from November 16, 2021, through December 7, 2021, was in violation of the Act. Because no one is currently using the acting title for this position, there is no continuing violation. 2. The Vacancies Act establishes requirements for temporarily authorizing an acting official to perform the functions and duties of certain vacant positions that require 15 U.S.C. Section 3345, 3349. D2. We contacted OMB to seek factual information and its legal views on the matter. Email from Assistant General Counsel for Appropriations Law, GAO, to General Counsel, OMB, December 7, 2021. Letter from Managing Associate General Counsel for Appropriations Law, GAO, to General Counsel, OMB, December 22, 2021. Email from Assistant General Counsel for Appropriations Law, GAO, to Deputy General Counsel, OMB, March 25, 2022. OMB responded with its explanation of pertinent facts, legal analysis, and supporting documents. OMB, responses to GAO's questions regarding B 333,857, February 16, 2022 OMB responses, Memorandum from Acting Director, OMB, to Associate Administrator, WERA, Delegation of Authorities, October 18, 2021, Block Delegation, Memorandum from Acting Director, OMB, to Deputy Administrator, WERA, Delegation of Authorities, January 31, 2022, Mancini Delegation, Memorandum from Acting Director, OMB, to Deputy Administrator, WERA, Designation of First Assistant to the WERA Administrator under the Federal Vacancies Reform Act of 1998, February 14, 2022, First Assistant Designation, Email from Deputy General Counsel, OMB, to Assistant General Counsel, for Appropriations Law, GAO, March 29, 2022 OMB March, 2022, Email, Presidential Appointment and Senate Confirmation, PAS Positions. The Act identifies 3 categories of persons who may temporarily perform the functions and duties of a vacant PAS position 5 U.S.C. Section 3345. The first assistant to the vacant position automatically serves as acting officer unless the President designates an individual in one of the other categories 5 U.S.C. Section 3345. 1. The President may designate as acting officer either 1. An individual serving in another PAS position or 2. A senior agency officer or employee who has served for a minimum period of time prior to the vacancy 5 U.S.C. Section 3345. 2. 3. If no nomination has been submitted for the vacant position, the Vacancies Act generally limits the period of acting service to 210 days beginning on the date the vacancy occurs 5 U.S.C. Section 3346. 1. But when a vacancy exists during the 60-day period beginning on the date of a presidential transitional inauguration, the 210-day period is extended by 90 days. Allowing for 300 days of acting service beginning on the transitional inauguration day or the date the vacancy occurs, whichever is later 5 U.S.C. Section 3349 B. If a nomination has been submitted, acting service is permitted during the pendency of a first or second nomination and, if the nominee is not confirmed, for up to 210 days after the date the first or second nomination is rejected, withdrawn, or returned 5 U.S.C. Section 3346. 2. B. After the expiration of the period of permissible acting service, the position must remain vacant and only the head of the agency may perform the functions or duties of the position 5 U.S.C. Section 3348. B.3 Under the provisions of Section 3349, b. The Comptroller General is required, upon a determination that an acting official has served longer than the allowable period, to report such findings to Congress, the President, and the Office of Personnel Management. OMB reported that the position of WERA administrator became vacant on January 19, 2021, for the day before a transitional presidential inauguration day, and, to date, no one has been nominated to the position. 5 In accordance with the Vacancies Act, the permissible period for acting service ended on November 15. 3 The Vacancies Act defines function or duty as any function or duty of the position that is established by statute or regulation, including any regulation in effect at any time during the 180-day period preceding the date of the vacancy, and required by statute or regulation to be performed by the applicable officer, and only that officer. 5 U.S.C. Section 3348. 2. 4 Although OMB initially reported to GAO that the vacancy began on January 20, 2021, see GAO's Executive Vacancy System, it clarified in its response that the vacancy began on January 19, 2021. OMB responses, at 1. 5 OMB responses, at 3. Page 2B 333857, 2021. 5 U.S.C. Section 3349 B.6 At the time of the vacancy, Dr. Dominic J. Mancini was serving as Deputy Administrator, the first assistant to the administrator position, and became acting administrator pursuant to the Vacancies Act on January 20, 2021. 7 C5 U.S.C. Section 3345. 1. On April 20, 2021, the President designated Sharon Block, Associate Administrator of WERA, to perform the duties of the administrator pursuant to Section 3345. 3. Of Title 5.8. This provision permits the President to direct an officer or employee of the agency to perform the functions and duties of a vacant position if such officer or employee served in a position at the agency for at least 90 days during the 365 days preceding the vacancy. 5 U.S.C. Section 3345. 3. A. OMB later determined on or around October 12, 2021, that, because Ms. Block had not served in her position for the requisite period prior to the vacancy, she was ineligible to serve as acting administrator under Section 3345. 3. And she ceased using the acting title on October 14, 2021. 9. Because there was no valid presidential designation of an acting official under Section 3345. 3. The default provision designating the first assistant as acting official continued to apply on and after April 20, 2021. See 5 U.S.C. Section 3345. 1. Accordingly, Dr. Mancini was authorized to perform the 6 because the vacancy existed on the transitional inauguration day. The 210-day period did not begin to run until 90 days after that date, April 20, 2021. See 5 U.S.C. Section 3349 B. 1. 7 GAO has previously determined that agency regulations or other documentation designating a first assistant position before a vacancy occurs are sufficient to establish that a position is the first assistant for purposes of the Vacancies Act. CB 332,995, August 2, 2021. OMB stated that the deputy administrator is the most senior career position reporting directly to the administrator, and the agency has long recognized the position as the first assistant to the administrator. OMB responses. At 1. OMB further stated that deputy administrators have served as acting administrator at various points during the last 4 presidential administrations. I'd see GAO's Executive Vacancy System, reflecting OMB reports of Dr. Mancini serving as acting administrator during vacancies in the 2 previous administrations. OMB reported that despite this long-standing treatment, it was unable to locate documentation of the original designation of the position as the first assistant and therefore formally memorialized the designation on February 14, 2022. OMB responses. At 1. First assistant designation. Although OMB was unable to provide such documentation in this case, we conclude that OMB's long-standing practice of treating the deputy administrator as the first assistant to the WERA administrator, as evidenced by the Deputy Administrator's service as acting administrator during previous vacancies, is sufficient to establish that the Deputy Administrator is the first assistant under the Vacancies Act. 8 OMB responses, at 2, 9 OMB responses, at 2, OMB March 2022, email, page 3B 333,857, functions and duties of the Administrator through November 15, 2021, the last day of permissible acting service, CID, 5 U.S.C. Section 3349 B, beginning on November 16, 2021, only the head of the agency was authorized to perform those functions and duties. C 5 U.S.C. Section 3348 B, 2.10. Although the period of permissible acting service ended on November 15, 2021, Dr. Mancini continued to be listed as acting administrator on notices of action issued by WERA from November 16, 2021, through December 7, 2021, in response to agency information collection requests under the Paperwork Reduction Act of 1995, PRA 11.12. When we inquired about a potential violation of the time limitations on acting service, OMB stated that it has been longstanding WERA practice for the name of either the administrator or deputy administrator to appear on PRA notices of action, and Dr. Mancini was inadvertently listed as both acting administrator and deputy administrator after November 15, 2021. 13 OMB stated that this was a clerical mistake, and Dr. Mancini's title on these notices has since been modified. 14 We have previously determined that an agency's identification of an individual as an acting officer on official agency documents issued after the end of the period of permissible acting service constitutes a violation of the Vacancies Act's time limitations. CB 328671, March 3, 2017, B 321357, July 18, 2016. It is immaterial 10 that an acting director of OMB delegated the authority to perform the delegable duties of the administrator of WERA to Ms. Block on October 18, 2021. Block delegation. The acting director redelegated that authority to Dr. Mancini on January 31, 2022, effective February 1, 2022. Mancini delegation. The term delegable is sometimes used to refer to a function or duty that does not fall within the Vacancies Act definition and is therefore not subject to the Act's restrictions. CB 321357, July 18, 2016. CF 5 U.S.C. Section 3348, 2, B, 2, D 1144 U.S.C. Section 3501 to 3520, 12 e.g., OMB, Notice of Office of Management and Budget Action, ICRF number 2021070, 0651, 001, November 16, 2021, available at https://www.reginfo.gov public do prav IEWICRF NBR equals 2021070, 0651, 001, last visited March 15, 2022, OMB, Notice of Office of Management and Budget Action, ICRF number 2021111, 0579, 011, November 30, 2021, available at https://www.reginfo.gov public do prav IEWICRF NBR equals 2021111, 0579, 011, last visited March 15, 2022, OMB, Notice of Office of Management and Budget Action, ICRF number 2021106, 0579, 011, December 7, 2021, available at https://www.reginfo.gov public do prav IEWICRF NBR equals 2021106, 0579, 011, last visited March 15, 2022. We did not identify any agency documents, publications, or websites identifying Ms. Block as acting administrator after the period of permissible acting service. 13 OMB responses, at 3:14 I'd page 4B 333,857, whether the identification was due to clerical error, c. e.g., B 332,618, January 19, 2021. Finding a violation despite agency's response that identification of individual as acting officer on website and Twitter account was a mistake and was corrected upon receipt of GAO's inquiry, B331539, September 18, 2020. Finding a violation despite agency's response that identification of individual as acting officer on website was a mistake that had been corrected. Use of the acting title conveys to Congress, the public, and other government agencies that an official is authorized to perform all of the functions and duties of the vacant position. See 5 U.S.C. Section 3348. B. It is therefore vital that officials cease using the acting title when the permissible period of acting service expires and they are no longer authorized to perform such functions and duties. See 5 U.S.C. Section 3348. B. D. Here, we find that OMB held Dr. Mancini out to the public as acting administrator of WERA after the period of permissible acting service by identifying him as acting administrator on PRA notices of action issued by WERA and published on its website. Dr. Mancini's use of the acting administrator title from November 16, 2021, through December 7, 2021, was not authorized by the Vacancies Act and violated the Act's time limitations. We also note here that Ms. Block's period of acting service from April 20, 2021 through October 13, 2021, 15 was not authorized by the Vacancies Act. However, she ceased using the title upon a determination that she had not served in her position for the requisite period prior to the vacancy and did not use the title after the permissible period of acting service for the vacancy had expired. Therefore, while Ms. Block's acting service was not authorized, her use of the acting title did not violate the Act's time limitations. In accordance with the requirements of the Vacancies Act, we are also sending letters reporting this violation to the chairs and ranking members of the Senate Committee on Homeland Security and Governmental Affairs, the House Committee on Oversight and Government Reform, the Senate and House Committees on Appropriations, the Senate and House Committees on the Budget, and the Director of the Office of Personnel Management. 15 OMB responses, at 2 OMB March 2022, email, stating that Ms. Block immediately ceased using the acting title on October 14, 2021 when she was notified she was not eligible to serve as acting administrator. Page 5B 333857. If you have any questions regarding this matter, please contact Shirley A. Jones, Managing Associate General Counsel, at 202-512-8156, or Charlie McKeever, Assistant General Counsel, at 202-512-5992. Sincerely yours, Etta Emanuele Perez, General Counsel. Page 6B 333857. Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice, 810 7th Street, NW, Washington, D.C. 20531. Telephone, 202-307-0690, TDY, 202-307-2027. Email, askocr@usdoj.gov. Website, www.ojp. .usdoj.gov. OCR Title 6 of the Civil Rights Act of 1964, 42 U.S.C. Section 2000D, prohibits discrimination based on race, color, or national origin in programs and activities that receive federal financial assistance. The Office for Civil Rights, OCR at the Office of Justice Programs, OJP, 1 U.S. Department of Justice. DOJ enforces Title 6 in 4 ways. 1. Responding to administrative complaints. 2. Initiating compliance reviews. 3. Providing technical assistance. And 4. Offering policy guidance. Administrative complaints. The OCR is the principal DOJ office that enforces Title 6 through the administrative process. 2. People who receive benefits or services from a DOJ-funded organization, and who believe that the organization discriminated against them based on race, color, or national origin, may file a complaint directly with the OCR. 3. The forms and instructions for filing an administrative complaint are available on the OCR's website at http://www.ojp.usdoj.gov about OCR complaints HTM. Over the last 4 years, the OCR has processed 346 docketed administrative complaints alleging discrimination in the delivery of services or benefits based on race, color, or national origin in a DOJ-funded program. 5 common complaints include allegations that a funded law enforcement agency engaged in unlawful racial profiling in conducting traffic stops, or that a funded correctional facility discriminated in the delivery of services to inmates. 6. When the OCR receives a timely complaint over which it has jurisdiction, it may initiate an investigation. 7. If the complaint has merit, the OCR works with the DOJ recipient aid to remedy the complaint, ensuring compliance with Title VI. Although the ultimate penalty, Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice for noncompliance with Title VI is the suspension or termination of federal financial assistance. 9. In the last 4 years, the OCR has always been able to secure the voluntary compliance of recipients with Title VI. Compliance reviews. The OCR has a vigorous Comply on Our Review program to enforce Title 6.10 in the last 4 years. OCR's Title VI compliance reviews have generally involved 3 groups of recipients. 1. State administering agencies, SAS, 11. 2. Law enforcement organizations, and 3. Juvenile justice systems. A compliance review is a civil rights audit that the OCR initiates. The investigation entails reviewing the policies and procedures of a recipient, determining whether the recipient is in compliance with Title VI and other federal civil rights laws, issuing findings and recommendations, and when warranted, monitoring the recipient to ensure it implements the OCR's recommendations for coming into compliance with Title VI and other federal statutes. State administering agencies. The OCR has conducted on-site civil rights compliance reviews of 107 SAS in all 50 states and U.S. territories. 12. A compliance review of NSA requires a thorough audit of all policies, procedures, and management practices related to the enforcement of Title VI. The compliance review examines not only whether the SA is itself in compliance with Title VI but also whether the SA has methods of administration, MOA, that ensure that its subrecipients comply with Title 6.13. MOAs, as they relate to Title VI enforcement, ordinarily include 1. The establishment of Title VI complaint procedures. 2. Notice provisions to subrecipients and beneficiaries about the application of Title VI to DOJ grant programs. 3. Procedures that SA program managers follow in monitoring the subrecipient's compliance with Title VI. And 4. Training programs for both the SA staff and the staffs of subrecipients on their responsibilities under Title VI. Each SA compliance review culminates in OCR's issuance of a thorough, written report, which states in detail where the SA is in compliance with the law and where it must correct shortcomings. Based on the recommendations in the Comply on Our Review report, the OCR monitors the SA, sometimes over a period of years, to ensure that it implements the report's recommendations. A common outcome of an SA compliance review is the SA's development of a civil rights monitoring checklist, which ensures that when SA program managers make Site 2, Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice visits to subrecipients, they are evaluating whether the subrecipients are in compliance with Title VI and other federal civil rights laws. 14. Another common outcome of an SA compliance review is that the SA strengthens its grievance procedures for accepting and resolving Title VI complaints. 15. Law enforcement agencies. The OCR pioneered conducting language access compliance reviews for DOJ, focusing on whether law enforcement agencies provide appropriate language access services to their limited English proficient (LEP) populations in accordance with Title 6.16. Since the 2002 publication of DOJ's Guidance for Recipients on Providing Services to LEP Beneficiaries, the OCR has conducted more than 100 language access compliance reviews of law enforcement agencies. A language access compliance review of a recipient law enforcement agency entails a comprehensive evaluation of all the recipient's policies and procedures that may relate to the delivery of services to LEP individuals and communities. The investigation includes a thorough review of all the recipient's standard operating procedures that affect LEP individuals. the recipient's training curriculum for sworn and civilian staff in public contact positions, the quality of the oral and written communication services the recipient provides for the predominant foreign language groups in the service area, and the recipient's outreach services for LEP communities. During each compliance review, OCR staff attorneys go into the field to determine how well a law enforcement agency is actually implementing its stated language access policies. As with the compliance reviews of SAWS, at the end of a language access compliance review, the OCR issues a Comply on Our Review report, which includes detailed recommendations on how the law enforcement agency should improve language access services. If a law enforcement agency does not have a formal language access plan, or if its plan is inadequate, the Comply on Our Review report recommends producing a language access plan in conformity with Title VI. The OCR monitors a law enforcement agency after the issuance of the Comply on Our Review report to ensure that it has adopted protocols to improve language access services. The OCR can document significant improvements in the services that law enforcement agencies provide to LEP communities throughout the country as a result of its compliance reviews. The improved services extend to all aspects of police work, including accepting 911-1 calls, dispatching officers to the scene of an emergency, responding to domestic violence incidents, investigating crimes, issuing accident and missing property reports, conducting interviews of suspects and witnesses, providing 3. Office for Civil Rights Office of Justice Programs U.S. Department of Justice Services to individuals in lockups, accepting and resolving complaints against officers, and meeting with neighborhood groups. One of the most extensive language access compliance reviews that the OCR conducted involved the New York City Police Department, NYPD. The NYPD's resident service population is 8.4 million, with 1.8 million being LEP. 17 Given the size and complexity of the investigation, the OCR, in consultation with DOJ statistical experts, targeted NYPD precincts and other points of service areas that had the highest numbers of LEP persons, using Geographic Information System, GIS shape files, demographic data from the U.S. Census Bureau, and data from New York City's Department of City Planning. The OCR's investigative team was able to create detailed maps for each NYPD precinct, showing for each census tract the size and language of its LEP population. Based on this analysis, the OCR selected for more careful on-site review 12 precincts, 2 transit headquarters, 2 transit districts, and 3 housing service areas. The OCR conducted over 100 interviews, meeting with NYPD's command staff, members of the uniform service, and civilian personnel. The OCR also conducted 3 meetings with community groups who had firsthand experience with the NYPD services to LEP communities. In November 2010, the OCR issued a Comply on Our Review report, which contained the OCR's findings along with recommendations to bring the NYPD into compliance with Title 6.18. The report advised NYPD to revise its language access policies, establish quality control measures for staff interpreters, provide better training to its uniform and civilian staffs, recruit additional officers with language skills, improve community relations, and translate vital documents into New York City's most commonly spoken foreign languages. The NYPD accepted the report's recommendations and worked with the OCR over 2 years to implement substantially all of them. As a result, the NYPD has come into better compliance with Title VI and vastly improved its services to New York City's LEP population. The OCR's language access compliance reviews have achieved similar results in law enforcement agencies throughout the country. Among the nation's 50 largest local police departments, the OCR has initiated language access compliance reviews in 38 of them. 19 juvenile justice systems in light of research that suggests that youth who are LEP, or have LEP families, receive more severe punishment in the juvenile justice system than those who are not. 20 The 4. Office for Civil Rights Office of Justice Programs U.S. Department of Justice OCR initiated language access compliance reviews under Title VI of the juvenile justice systems in Adams and Arapahoe counties, Colorado, Douglas County, Nebraska, Fairfax County, Virginia, Hennepin County, Minnesota, Milwaukee County, Wisconsin, Newcastle County, Delaware, Pima County, Arizona, Prince George's County, Maryland, Santa Clara County, California, and Suffolk County, Massachusetts. 21 The OCR examined the language, Access services that are available to apprehended youth in each of the selected jurisdictions, focusing on pre-adjudication services. As the juvenile justice systems in each locale differ significantly from each other, the compliance reviews required identifying the multiple DOJ recipients in a selected community that serve juveniles and then determining how the recipient agencies work together in providing a range of services. For example, in New Castle County, Delaware, the OCR reviewed the language access services of the Delaware Administrative Office of the Courts, the Family Court, the Justice of the Peace Court, the Delaware Department of Justice, the Delaware Office of the Public Defender, and the Delaware Department of Services for Children, Youth and their Families. The OCR concluded that these recipients were not fully in compliance with Title VI, although they had taken some steps to provide LEP individuals with meaningful access to juvenile justice services. 22. The Compliance Review Report documented each recipient's deficiencies and provided detailed recommendations for improving language access services to both LEP juveniles and LEP families. Technical assistance. One of the OCR's most effective tools for enforcing Title VI is through technical assistance, instructing recipients about their responsibilities under the law and informing beneficiaries of Title VI's protections. Into all of its compliance reviews of SAWS, the OCR has incorporated training programs for SAW staff on the importance of Title VI, with an emphasis on improving monitoring procedures to ensure the compliance of subrecipients. The OCR has developed a series of easily accessible online training programs that provide information, not only to recipients but also to beneficiaries, on Title VI and other federal civil rights statutes. The training programs are available on OCR's website at http://www.ojp.usdoj.gov. About OCR Assistance HTM. The OCR provides technical assistance to SAWs that choose to develop their own training programs on Title VI for their staffs and subrecipients. On request, the OCR may also conduct training programs on Title VI and related statutes for DOJ-funded organizations. 5. Office for Civil Rights Office of Justice Programs U.S. Department of Justice. In recognition of OCR's extensive experience in conducting civil rights investigations, other federal agencies have requested that the OCR train their civil rights investigators. For example, in FY 2013, OCR has provided day-long training programs for the civil rights offices at the U.S. Department of Labor and the U.S. Department of Agriculture. The OCR has also lent staff attorneys in FY 2013 to the faculty of the Academy for Civil Rights Investigators, sponsored by the U.S. Department of Health and Human Services at the National Advocacy Center in Columbia, South Carolina. The Academy trains civil rights investigators from a variety of federal agencies. OCR attorneys presented a series of lectures that addressed the legal and procedural considerations in a Title VI investigation, culminating in a practicum for both staff investigators and their supervisors. Policy guidance. The OCR has strengthened the enforcement of Title VI through its policy guidance to DOJ grant-making offices. Consistent with OCR's advice, DOJ grant-making offices have 1. Added a special condition to grants for SAWs, requiring them to develop written MOAs for monitoring the compliance of subrecipients. 2. Placed an explicit reference to Title VI in grant solicitations. 3. Inserted compliance with Title VI in standard grant assurances. And 4. Included with all award letters to recipients notice of the requirement under Title VI to serve LEP beneficiaries. Special conditions. Based on OCR's comprehensive work in conducting compliance reviews of SAWs, OCR recommended that DOJ grant-making offices add, beginning in FY 2013, a special condition to all awards to SAWs, requiring them to develop written MOAs to ensure the compliance of subrecipients with Title VI and other applicable federal civil rights laws. The language of the special condition is as follows. The recipient understands and agrees that it has a responsibility to monitor its subrecipients' compliance with applicable federal civil rights laws. The recipient agrees to submit written methods of administration, MOA, for ensuring subrecipients' compliance to the OJP's Office for Civil Rights at civilrightsmoa@usdoj.gov within 90 days of receiving the grant award, and to make supporting documentation available for review upon request by OJP or any other authorized persons. The required elements of the MOA are set forth at http://www.ojp.usdoj.gov. Funding. Other requirements. HTM. Under the heading Civil rights compliance specific to state administering agencies. 6. Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice. The MOAs that SOS submit must include 4 elements. 1. The SOS policy for addressing discrimination complaints. 2. The SOS method for notifying its subrecipients of their civil rights obligations. 3. The SOS procedures for monitoring the compliance of its subrecipients with applicable federal civil rights laws. And 4. The SOS training program for its subrecipients on the applicable civil rights requirements. 23. Since the beginning of FY 2013, the OCR has reviewed the MOAs that many SOS have submitted. When there have been deficiencies in an MOA, the OCR has worked with the SA to bring it into compliance with the special condition. Solicitations in OJP. Solicitations announcing the availability of grant funds. The grant-making offices inform potential applicants that, as a condition for receiving funds from OJP, recipients must comply with Title VI. The following language generally appears in solicitations. Compliance with Title VI of the Civil Rights Act of 1964, which prohibits recipients from discriminating on the basis of national origin in the delivery of services or benefits, entails taking reasonable steps to ensure that persons with limited English proficiency, LEP, have meaningful access to funded programs or activities. An LEP person is one whose first language is not English and who has a limited ability to read, write, speak, or understand English. To assist recipients in meeting their obligation to serve LEP persons, the Department of Justice (DOJ) has published a guidance document, which is available on the lep.gov website. OJP encourages applicants and recipients to include within their program budgets the costs for providing interpretation and translation services to eligible LEP service populations. 24. Standard assurances as a condition for receiving federal financial assistance. The OJP requires potential recipients to certify during the application process a document known as the Standard Assurances, acknowledging the obligation to comply with Title VI. The relevant language in the Standard Assurances is as follows. The applicant also specifically assures and certifies that IT will comply, and will require any subgrantees or contractors to comply, with any statutorily imposed non-discrimination requirements, which may include the Civil Rights Act of 1964, 42 U.S.C. Section 2000 D,25-7, Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice award letters as part of the grant award package that every recipient receives. The director of the OCR sends a letter notifying the recipient of its civil rights obligations under Title VI. The letter informs the recipient of prohibited national origin discrimination and notes the recipient's obligation to take reasonable steps to provide meaningful access to programs and activities for LEP persons. 26. Additional information on the OCR's work to enforce Title VI is available on its website at http://www.ojp.usdoj.gov. OCR 1. The OCR is not a part of the Civil Rights Division. It is a separate Civil Rights Enforcement Office connected to the DOJ grant-making offices. The OCR's role within DOJ is comparable to the role of civil rights offices at other large federal agencies, such as the Office for Civil Rights at the U.S. Department of Education or the Office for Civil Rights at the U.S. Department of Health and Human Services. The federal regulation implementing the administrative process for enforcing Title VI is 28 CFR Part 42, Sub. C2. The OCR enforces Title VI for the following DOJ components: the Office of Community-Oriented Policing Services, the Office on Violence Against Women, and the Office of Justice Programs, which includes the Bureau of Justice Assistance, the Bureau of Justice Statistics, the National Institute of Justice, the Office for Victims of Crime, the Office of Juvenile Justice and Delinquency Prevention, and the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking. 3. In addition to Title VI, the OCR also enforces federal laws that prohibit discrimination in DOJ-funded programs based on race, color, national origin, sex, religion, disability, age, sexual orientation, and gender identity. For the time period is from the beginning of FY 2009, October 1, 2008, to the present, April 20, 2013. 5. Although Title VI prohibits discrimination based on race, color, or national origin in all federally assisted programs. Other DOJ program statutes include similar as well as other broader protections. C. E.g., the Omnibus Crime Control and Safe Streets Act, Safe Streets Act, of 1968, as amended, 42 U.S.C. Section 3789d, c. Prohibiting recipients under the statute from discriminating in both employment and in the delivery of services or benefits based on race, color, national origin, sex, and religion. If an organization receives funding subject to the Safe Streets Act, the OCR would ordinarily follow the administrative procedures of the Safe Streets Act in investigating and resolving claims that allege discrimination based on race, color, or national origin. See 28 CFR Part 42, Sub. D6C, e.g., Fairfax County, VA, Police Dept. Number 090CR0440, Office for 104, RTSLTR of Finding, U.S., Dept of Justice, October 28, 2009, available at http://www.ojp.ustoj.gov about OCR PDFS Fairfax Cop PDF 728 CFR Section 42.107, B. C8 The implementing regulation for Title VI provides the following definition for recipient. The term recipient means any state, political subdivision of any state, or instrumentality of any state or political subdivision, any public or private agency, institution, or organization, or other entity, or any individual, in any state, to whom federal financial assistance is extended, directly aid, Office for Civil Rights Office of Justice Programs U.S., Department of Justice or through another recipient, including any successor, assign, or transferee thereof, but such term does not include any ultimate beneficiary. IDE Section 42.102, F9 IDE Section 42.110, F10 IDE Section 42.107. A 11A state administering agency is the principal bureau in a state government that receives DOJ funding and then subawards it to other state agencies, units of local government, Indian tribes, or nonprofit organizations. 12 Office of Justice Programs, Office for Civil Rights Investigative Findings, http://www.ojp.ustoj.gov about OCR Invest Find HTM, last visited APR 20, 2013. A partial listing of SAW comply on our review reports that the OCR issued in FY 2013 includes the following entities: the American Samoa Criminal Justice Planning Agency, the Arkansas Department of Human Services, the Guam Department of Youth Affairs, the Guam Office of the Attorney General, the Guam Office of the Governor, and the Hawaii Department of Human Services. 13 C28 CFR Section 42.105, D. 2, 14C, e.g., Office of Justice Programs, Sample Documentation, http://www.ojp.ustoj.gov about OCR Sample Documentation HTM, last visited APR 20, 2013, 15 IDE 16 CUS, Dept of Justice, Guidance to Federal Financial Assistance Recipients regarding Title VI Prohibition against National Origin Discrimination affecting limited English proficient persons, 67 Fed, Reg 41455, June 18, 2002, available at http://www.gpo.gov size PKGFR June 18, 2002 PDF 02-15207. PDF 17 New York City Police Dept. Number 10 OCR 0015 Office for 104 RTS Comble, Reverend Rep 3 and N 3 U.S. Dept. of Justice, November 8, 2010. Available at http://www.ojp.ustoj.gov about OCR PDF SNP Compliance Report PDF 18 IDE 143, 19 In December of 2010, the Bureau of Justice Statistics issued a report that identified the 50 largest local police departments in the United States. Bureau of Justice Statistics, Local Police Departments, 2007 at 34 at TBL, 1, December 2010, available at http://www.bjs.gov Content Pub PDF LPD 07 PDF. In reference to this report, The OCR has initiated language access compliance reviews of the following police departments in descending order of size: New York, New York, Police Dept. Chicago, IL, Police Dept. Philadelphia, PA, Police Dept. Houston, Tex, Police Dept. Washington, D.C., Metropolitan Police Dept. Dallas, Tex, Police Dept. Miami-Dade, FLA, Police Dept. Baltimore, MD, Police Dept. Las Vegas, NET, Metropolitan Police Dept. San Francisco, Cal, Police Dept. Boston, Mass, Police Dept. Memphis, 10 Police Dept. Milwaukee, WIS, Police Dept. San Diego, Cal, Police Dept. Honolulu, HA, Police Dept. Baltimore County, MD, Police Dept. Columbus, Ohio, Police Dept. Atlanta, GA, Police Dept. Indianapolis, IND, Police Dept. Cleveland, Ohio, Police Dept. Denver, Colo Police Dept. Prince George's County, MD, Police Dept. Charlotte Mecklenburg, NC, Police Dept. Fairfax County, VA, Police Dept. Fort Worth, Tex, Police Dept. Kansas City, MO, Police Dept. San Jose, Cal, Police Dept. St. Louis, MO, Police Dept. Seattle, Wash, Police Dept. Montgomery County, MD, Police Dept. Louisville, Chi, Police Dept. Cincinnati, Ohio, Police Dept. Miami, FLA, Police Dept. Tucson, Aris, Police Dept. Oklahoma City, OCLA, Police Dept. Tampa, FLA, Police Dept. Long Beach, Cal, Police Dept. And Albuquerque, NM, Police Dept. The OCR has not issued the final comply on our review reports for the police departments in the above list that have an asterisk 20C, e.g., Vera Institute of Justice. If parents don't speak English well, will their kids get locked up? October 2007, available at http://www.vera.org. Sites default files resources downloads language barriers and disproportionate minority contact in the juvenile justice system PDF 9. Office for Civil Rights Office of Justice Programs U.S. Department of Justice 21. The comply on our review reports for Newcastle County, Delaware, and Santa Clara County, California, are available online. See Office of Justice Programs, Office for Civil Rights Investigative Findings, http://www.ojpus.gov. About OCR Invest Find HTM, last visited APR 20, 2013. The OCR has issued comply on our review reports for Fairfax County, Virginia, Douglas County, Nebraska, and Milwaukee County, Wisconsin. The reports are on file with the OCR and will appear shortly on the OCR's website. The OCR has not yet issued final comply on our review reports for Adams and Arapahoe counties, Colorado, Hennepin County, Minnesota, Pima County, Arizona, Prince George's County, Maryland, and Suffolk County, Massachusetts. 22 Del Admin, Office of the CTS, et al., number 090CR0475-0477, 0193, Office for 104, RTS Compl, Reverend Rep., U.S., Dept of Justice, December 4, 2009, available at http://www.ojp.usdoj.gov. About OCR PDF SD09 OCR 0475 0193 PDF 23 Office of Justice Programs Other Requirements for OJP Applications Civil Rights Compliance Specific to State Administering Agencies http://www.ojp.usdoj.gov. Funding Other Requirements HTM last visited APR 20, 2013, 24 ID Civil Rights Compliance http://www.ojp.usdoj.gov. Funding Other Requirements HTM last visited APR 20, 2013, 25 Office of Justice Programs Standard Assurances http://www.ojp.usdoj.gov. Funding Forms STD Assurances PDF last visited APR 20, 2013, 26 Office of Justice Programs Sample Award Letter http://www.ojpusdoj.gov. Financial Guide PDFs Award PDF last visited APR 20, 2013, 10. Hmm. Hmm. U.S. Department of Justice certified standard assurances on behalf of the applicant, and in support of this application for a grant or cooperative agreement, I certify under penalty of perjury to the U.S. Department of Justice Department, that all of the following are true and correct. 1. I have the authority to make the following representations on behalf of myself and the applicant. I understand that these representations will be relied upon as material in any department decision to make an award to the applicant based on its application to. I certify that the applicant has the legal authority to apply for the federal assistance sought by the application, and that it has the institutional, managerial, and financial capability, including funds sufficient to pay any required non-federal share of project costs, to plan, manage, and complete the project described in the application properly. 3. I assure that, throughout the period of performance forthward, if any, made by the department based on the application, A. The applicant will comply with all award requirements and all federal statutes and regulations applicable to the award. B. The applicant will require all subrecipients to comply with all applicable award requirements and all applicable federal statutes and regulations. And C. The applicant will maintain safeguards to address and prevent any organizational conflict of interest, and also to prohibit employees from using their positions in any manner that poses, or appears to pose, a personal or financial conflict of interest. 4. Capital T, H, E, capital A, P, P, L, I, C, A, N, T, U, N, D, E, R, S, T, A, N, D, S, T, H, A, T, T, H, E, applicable to the award, if any, made by the department based on the application specifically include statutes and regulations pertaining to civil rights and non-discrimination, and, in addition, A. The applicant understands that the applicable statutes pertaining to civil rights will include Section 601 of the Civil Rights Act of 1964, 42 U.S.C. Section 2000 D, Section 504 of the Rehabilitation Act of 1973, 29 U.S.C. Section 794, Section 901 of the Education Amendments of 1972, 20 U.S.C. Section 1681, and Section 303 of the Age Discrimination Act of 1975, 42 U.S.C. Section 6102. B. The applicant understands that the applicable statutes pertaining to non-discrimination may include Section 809, C, of Title I of the Omnibus Crime Control and Safe Streets Act of 1968, 34 U.S.C. Section 10228, C, Section 1407, E, of the Victims of Crime Act of 1984, 34 U.S.C. Section 20110, E, Section 299A, B, of the Juvenile Justice and Delinquency Prevention Act of 2002, 34 U.S.C. Section 11182, B, and that the grant conditions set out at Section 40002, B, 13, of the Violence Against Women Act, 34 U.S.C. Section 12291, B, 13, which will apply to all awards made by the Office on Violence Against Women, also may apply to an award made otherwise. C. The applicant understands that it must require any subrecipient to comply with all such applicable statutes and associated regulations. And D. On behalf of the applicant, I make the specific assurances set out in 28 CFR Section 42.105 and 42.204. 5. Capital T, H, E, capital A, P, P, L, I, C, A, N, T, A, L, S, O, U, N, D, E, R, S, T, A, N, D, S, T, H, A, in addition to an applicable program, specific regulations and to applicable federal regulations that pertain to civil rights and non-discrimination. The federal regulations applicable to the award, if any, made by the department based on the application may include, but are not limited to, 2 CFR, Part 2800, the DOJ Part 200 Uniform Requirements, and 28 CFR, Parts 22, Confidentiality, Research and Statistical Information, 23, Criminal Intelligence Systems, 38, regarding faith-based or religious organizations participating in federal financial assistance programs, and 46. Human Subjects Protection. 6. I assure that the applicant will assist the department as necessary, and will require subrecipients and contractors to assist as necessary, with the department's compliance with Section 106 of the National Historic Preservation Act of 1966, 54 U.S.C. Section 306,108, the Archaeological and Historical Preservation Act of 1974, 54 U.S.C. Section 312,501-312,508, and the National Environmental Policy Act of 1969, 42 U.S.C. Section 4321, 4335, and 28 CFR, Part 61, NEPA, and 63, Floodplains and Wetlands. 7. I assure that the applicant will give the department and the Government Accountability Office, through any authorized representative, access to, and opportunity to examine, all paper or electronic records related to the award, if any, made by the department based on the application. 8. If this application is for an award from the National Institute of Justice or the Bureau of Justice Statistics pursuant to which award funds may be made available, whether by the award directly or by any subaward at any tier, to an institution of higher education, as defined at 34 U.S.C. Section 10,251, 17. I assure that, if any award funds actually are made available to such an institution, the applicant will require that, throughout the period of performance, each such institution comply with any requirements that are imposed on it by the First Amendment to the Constitution of the United States, and be subject to Part A, each such institution comply with its own representations, if any, concerning academic freedom, freedom of inquiry and debate, research independence, and research integrity, at the institution, that are included in promotional materials, in official statements, in formal policies, in applications for grants, including this award application, for accreditation, or for licensing, or in submissions relating to such grants, accreditation, or licensing, or that otherwise are made or disseminated to students, to faculty, or to the general public. 9. I assure that, if the applicant is a governmental entity, with respect to the award, if any, made by the department based on the application, A. It will comply with the requirements of the Uniform Relocation Assistance and Real Property Acquisitions Act of 1970, 42 U.S.C., B. Section 4601, 4655, which govern the treatment of persons displaced as a result of federal and federal law-assisted programs, and it will comply with requirements of 5 U.S.C. Section 1501 to 1508 and 7324, 7328. Which limit certain political activities of state or local government employees whose principal employment is in connection with an activity financed in whole or in part by federal assistance. 10. If the Community-Oriented Policing Services, COPS Office, I assure that as required by 34 U.S.C. Section 10,382, c. 11, it will, to the extent practicable and consistent with applicable law, including, but not limited to, the Indian Self-Determination and Education Assistance Act, seek, recruit, and hire qualified members of racial and ethnic minority groups and qualified women in order to further effective law enforcement by increasing their ranks within the sworn positions, as provided under 34 U.S.C. Section 10,382, c. 11. 11. If the applicant applies for and receives a DOJ award under the Stop School Violence Act program, I assure as required by 34 U.S.C. Section 10,552, 3, that it will maintain and report such data, records, and information, programmatic and financial, as DOJ may reasonably require. I acknowledge that a materially false, fictitious, or fraudulent statement, or concealment or omission of a material fact, in this certification, or in the application that it supports, may be the subject of criminal prosecution, including under 18 U.S.C. Section 1001 and/or 1621, and/or 34 U.S.C. Section 10,271, 10,273, and also may subject me and the applicant to civil penalties and administrative remedies for false claims or otherwise, including under 31 U.S.C. Section 3729, 3730, and 3801, 3812. I also acknowledge that the department's awards, including certifications provided in connection with such awards, are subject to review by the department, including by its Office of the Inspector General. Applicant applies for and receives an award from the Office of
More stuff to show. Well, this ought to be interesting. We select everything here.
June 30th, 2022. Table of Contents. Table of Contents. 2. Executive Summary. 3. Overview of the planned use of the funds. 5. Funding. Allocation by category and amount. 5. Community engagement. 6. Community written comments. 6. Community survey. 7. Pre-application process and summary. 8. Promoting equitable outcomes. 10. Project inventory. 12. Performance report. 16. Clark County Recovery Plan Performance Report 2022 Report Page Point 2. Executive Summary. This report serves as the first Recovery Plan Performance Report, Recovery Report, as required by the United States Department of Treasury, under the provisions of the Coronavirus State Fiscal Recovery Fund, and the Coronavirus Local Fiscal Recovery Fund established under the American Rescue Plan Act, ARPA. This report provides the information requested in the state and local fiscal recovery funds, compliance and reporting guidance from Treasury. Clark County received $440 million in fiscal recovery funds to mitigate the impacts of the COVID-19 pandemic, including social, medical, and economic impacts. Since the declaration of the public health emergency, approximately 25% of Clark County's population have contracted COVID-19, of which 1.6% have died. In addition to the health impacts, the economic impact from COVID-19 has also had a devastating effect on the Clark County economy. The economic impact has been the worst experienced in any metropolitan area of the United States, due to the high reliance on the leisure and hospitality industry that employs roughly 30% of the county's workforce. With the total shutdown of tourism and entertainment, including the Las Vegas Strip, the regional unemployment rate reached 33.5%, the highest in the nation. As a result of the economic downturn, the county lost more than $500 million in tax and fee revenue critical to serving the community's public health and safety needs. The fiscal recovery funds are also intended to support investments in programs and initiatives that create equitable outcomes within communities that have historically experienced disparate negative economic, health, and social impacts and have suffered the most from the COVID-19 pandemic. Fiscal recovery funds are available for a broad range of uses related to COVID-19 recovery efforts. Possible uses include affordable housing, rental assistance, aid to small businesses and nonprofit organizations, vaccine programs, enhancements to public health systems, investments in water, sewer, and broadband infrastructure, other areas of need, such as job retraining, and revenue replacement for the provision of government services. Important provisions of the law allow for an even broader range of uses in low-income communities that have been especially hard hit by COVID-19. Those eligible uses include investments to address homelessness and other housing issues, investments in education to address disparities, and several areas designed to help with child care and children's welfare. Funding is one-time and must be allocated by the end of calendar year 2024 and fully spent or returned by the end of calendar year 2026. The $440 million Fiscal Recovery Fund allocation presents Clark County with the opportunity to build capacity to meet the needs of populations disproportionately impacted by the pandemic and to strengthen its programs and services in a way that improves the quality of life for all community members. In order to understand the needs of the community, Clark County implemented a robust community engagement process. The community engagement process included participation from members of the disproportionately impacted communities, community stakeholders, and elected officials. Management Clark County Recovery Plan Performance Report 2022 Report page point 3. Partners, a management consulting firm, in partnership with the National Forum for Black Public Administrators, NFBPA, was retained to assist the county in this effort. As the Clark County community recovers from the devastating effects of the pandemic, the community needs have changed since the initial recovery plan. Since the last recovery plan, the county allocated fiscal recovery funds to replace lost revenue to ensure the public health and safety of the community. Concurrently, the county intends to address long-term recovery investments to support the community needs identified in the community engagement process with non-federal county funds. Based on public comments, the community survey, and the pre-application process, and the significant loss of county revenues as a result of the pandemic, the recovery plan recommends that the fiscal recovery funds be allocated in the broad categories and amounts shown in Figure 1. Figure 1. Clark County recommended funding allocation by category and amount, in millions. $45.20 10% $26.90 6% 60 cents 0% $367.50 84% revenue replacement negative economic impacts public health other given the robust community engagement process undertaken. Clark County is confident that this funding allocation will support an equitable and strong recovery from the COVID-19 pandemic and economic downturn and will ensure program outcomes are achieved in an effective and efficient manner. Clark County Recovery Plan Performance Report 2022 Report page point 4. Overview of the planned use of the funds. The fiscal recovery funds present Clark County with the opportunity to build community capacity to meet the needs of populations disproportionately impacted by the pandemic and to strengthen its programs and services in a way that improves the quality of life for community members. Clark County began a robust community engagement process to determine the use of fiscal recovery funds. This included several interviews with community leaders and stakeholders, community surveys, and a grant pre-application process. County leaders determined that the primary use of the state and local fiscal recovery funds should be to maintain public safety in the community while also supporting the needs identified in the pre-application and community engagement process. The allocation below should serve as a basis to prioritize the funding across the many programs and projects submitted. Funding allocation by category and amount. Table 1 provides an overview of the recommended funding amounts. Table 1. Summary of funding allocation by category and amount. 1.1 Vaccination 1.2 Prevention in congregate settings, nursing homes, homeless shelters, jails. 1.6 Medical expenses 1.7 1.11 Community violence intervention 1.12 1.13 Substance abuse 1.14 2.1 2.2 Rent, mortgage, and utility assistance 2.10 Healthy childhood environments, services to foster youth or families involved in child welfare system 2.16 2.18 Housing support, other housing assistance 2.29 Clark County Recovery Plan Performance Report 2022 Report expenditure category allocation programming amount, in millions. Public health negative economic impacts testing $0.11 40 0.11.41.53.00.79.44.03.0 page point 5 Other COVID-19 public health expenses including communications enforcement isolation quarantine 15.4 mental health 3.7 Other public health services 1.4 Food programs 4.3 Assistance to unemployed or underemployed workers 0.6 2.13 Long-term housing security services for unhoused persons 10.2 Loans or grants to mitigate financial hardship 9.0 Expenditure category allocation programming amount, in millions. Public health negative economic impact. Public sector capacity broadband revenue replacement and administration total 2.31 Business incubators and start up or expansion assistance 2.37 3.15.17 Broadband other projects 6.1 Provision of government services 7.1 Community engagement 1.00.3 $367.50 440.21 Economic impact assistance other 3.5 Public sector workforce payroll and benefits for public health, public safety, or human services workers 0.01, administrative expenses 0.5. The community engagement strategy included in-person and virtual interviews and public meetings, along with opportunities for community members to provide written comments. Specifically, the community engagement strategy included interviews with community leaders, 4 community workshops, 8 in-person and virtual neighborhood meetings, a grant pre-application process, written public input, and 2 surveys. The number of attendees that participated in these meetings spanned from 20 to 100 community members. Participants at each session reflected the racial, ethnic, and socioeconomic diversity of locations where the meetings were held. Attendees shared experiences and concerns regarding rapid increases in rent following the expiration of the eviction moratorium, lack of available affordable and transitional housing, insufficient behavioral health services, lack of resources to theaters and galleries, and inaccessibility to immigration resources. Community written comments. In addition to the structured public input collected for this plan, Clark County invited community members to share their interests and needs in writing. Clark County collected 592 comment cards during July and August 2021. Of these, 578 of the written comments endorsed expanding community navigation services and providing financial assistance to families and individuals in need. The remaining written input included requests to increase affordable and transitional housing, enhance broadband, improve transit, offer cooling centers, and provide small business and job training assistance. Clark County Recovery Plan Performance Report 2022 Report, page 0.6. Community survey. In collaboration with Clark County leadership, management partners developed and administered a community survey in multiple languages to understand the impacts of the pandemic in Clark County and residents' priorities for fiscal recovery funding. The survey was publicized on the county website, social media, shared by Clark County commissioners, and provided in paper form at county offices and in-person neighborhood meetings. A total of 3,532 responses were received, of which 3,103 were received in English, 413 in Spanish, and 16 in Tagalog. Respondents were asked a series of demographic questions to help county leaders and staff understand the disparate impacts of the pandemic on different communities. The largest respondent age group were those aged 35 to 49, representing 40.4% of respondents. Respondents were asked to consider 16 areas of potential need in the community and rank their top 5 areas of concern in priority order. The results are shown in Figure 2 below. Figure 2, top 10 areas of community needs as ranked in the Community Survey: 1, 601, 401, 201, 000, 800, 600, 400, 200, 0. First priority, second priority, third priority, fourth priority, fifth priority. Overall, the highest ranking needs included affordable housing, mental health services, homelessness, health care, and education. The community survey also provided insight into the depth of the negative economic impacts experienced by Clark County residents. Of the respondents, 36% indicated they had either lost a job or experienced reduced employment due to the COVID-19 pandemic. In addition to the community survey, Clark County completed a survey of nonprofit organizations. The responses supported the community survey results. All nonprofit organizations that responded to the survey indicated that they had experienced a greater demand for services. Clark County and management partners believe that the nonprofit organizations used the pre-application process to fully express their perspectives on community needs. Clark County Recovery Plan Performance Report 2022 Report, page 0.7. Pre-application process and summary. In July 2021, Clark County initiated a pre-application process to ascertain the breadth and depth of stakeholder interest and their understanding of the community recovery needs. Clark County stakeholders and community members were invited to submit pre-applications for fiscal recovery funds. The county advertised the call for pre-applications, posted the information on its website and social media, emailed the pre-application to current partner agencies, and made verbal announcements at Clark County meetings throughout July and August 2021. The county has established a three-phase process in evaluating pre-applications from nonprofit organizations, government agencies, and county departments as follows. Figure 3. Three-phase approach. Phase 1. Programs less than $100,000 providing immediate assistance. Phase 2. Programs greater than $100,000 providing immediate response and recovery services implemented within 90 days. Phase 3A and 3B. Programs and projects greater than $100,000 providing long-term investments needed to respond and recover from the pandemic. The phases will be funded through a combination of fiscal recovery funds and other non-federal sources. Due to the small size and scope of Phase 1 projects, these awards have presented an opportunity to further develop and expand the nonprofit community in Clark County and have been funded through non-federal county revenues. Phase 2 programs are continuing to address the immediate response needs in the community through a combination of services provided through nonprofit organizations and county departments. The majority of Phase 2 programs were implemented in the spring of 2022, resulting in minimal performance data as of June 30, 2022. Phase 3A and Phase 3B programs represent programs and capital projects that will address the long-term recovery investments needed in the county, ranging from affordable housing development, water improvements, broadband expansion, workforce development, and small business programs. While small business programs will be funded through the fiscal recovery funds, the remaining programs will be funded consistent with the community needs identified in the community engagement process over Clark County Recovery Plan Performance Report 2022 Report page .8. Several years but with non-federal county funds. The funding source and status of each phase is as follows. Table 2. Number of projects by phase and amount obligated. No of amount funding. Phase description. Projects in millions. Source program status. $100,000 serving immediate needs. Phase 1 is greater than $100,000. $38 2.5 non-federal funds. Programs in progress. Phase 2A non-profit serving immediate needs. $100,000. $10 2.5 non-federal funds. Programs in progress. Phase 2B nonprofit serving immediate needs. $100,000 serving immediate needs. $12 29.3 fiscal recovery funds. ARPA. Programs in progress. Phase 2C county departments. $12 33.3 fiscal recovery funds. ARPA. Programs in progress. Phase description. No of applications. Amount requested. Plan funding source. Application status. Final applications due in April 2022. Awards expected August 2022. Phase 3A long-term recovery investments. $292 1.5 billion non-federal funds. Phase 3A small business programs in progress. Fiscal recovery funds. ARPA. Applications in progress. Final applications due in June 2022. Expected September 2022. Phase 3B affordable housing. $39 287 million non-federal funds. Clark County Recovery Plan Performance Report 2022 Report page .9. Promoting equitable outcomes throughout the process of exploring how best to use the fiscal recovery funds. Clark County prioritized those communities and households hardest hit by the pandemic that have also been historically disadvantaged. Many employees in the leisure and hospitality industry have been unemployed and unable to pay for their basic needs, including rent, utilities, and food. County leaders have also prioritized recovery efforts within the approximately 100 QCTs in the county. Table 3. 89,106, 89,102, 89,115, 89,104 most distressed. Clark County zip code 2019 population 2019 below poverty level 2019 median HHD income COVID-19 cases as of July 26, 2021 rate per percent of county capita average 89,101. 42,592 34.2% 25,310 6,256 0.147 120% 26 480 31.0% 39 449 30.5% 63 084 28.3% 39 443 24.6% $29,906 $3,652 36 729 $4,649 39 412 $8,945 36 448 6,343 0.138 113% 0.118 97% 0.142 116% 0.161 132% 89,030 50,417 30.7% $36 275 8,691 0.172 141% 89,169 21,822 29.7% $30,581 2,585 0.118 97% 89,119 52,378 25.1% $35,705 5,844 0.112 91% source, Census Bureau and Southern Nevada Health District collectively. These areas have a population of approximately 330,000. 6 of the 8 most distressed areas have a majority of Black or Hispanic populations. None of these areas have broadband access to 80% of their households. The efforts to promote equitable outcomes include short-term assistance such as eviction prevention and housing assistance. Equitable outcomes are also focused on midterm and long-term investments to address mental and behavioral health service needs and efforts to boost the county's historically low educational attainment rates. Clark County Recovery Plan Performance Report 2022 Report page .10. In obligating fiscal recovery funds under Phase 2, the county evaluated each program based on the following priority matrix, with 25% of the evaluation weighted in favor of programs serving communities in a QCT or otherwise disproportionately impacted community as follows. Table 4. Priority matrix compliance with county regulations and conflict of interest standards weighting factors. 25% emphasis on low-income communities. 1. Federal priority assists QCTs and disproportionately impacted communities. 3. Alignment with county priorities. 4. Alignment with regional community needs assessments. 5. Leverages county services. 6. Fiscal sustainability. 7. Benefits low-income impoverished neighborhoods. 8. Leverages non-county funding. 9. Uses service providers with a demonstrated commitment to inclusionary and diversity practices. 10. Provides measurable and proven outcomes for Clark County. To date, the county has obligated a total of $62.6 million for 12 projects through nonprofit organizations and 12 projects through county departments, of which $48.3 million or 77% of the Phase 2 projects will serve a low-income or disproportionately impacted community. The following is a summary of the Phase 2 projects serving low-income or disproportionately impacted communities. Table 5. Phase 2 projects pass-fail factors: compliance with fiscal recovery funds guidance. 2. Alignment with state top 4. Strategies in the Every Nevadan Recovery Framework. Phase description: total No of projects serving low-income or disproportionately impacted communities. Total obligation in millions. Obligations serving low-income or disproportionately impacted communities in millions. Phase 2B non-profits: $100,000 serving immediate needs. 12 10 $29.20 $18.20. Phase 2C county department: $100,000 serving immediate needs. 12 7 $33.20 $30.10. Clark County Recovery Plan Performance Report 2022 Report page .11. Project Inventory Table 6. Summary of projects by category and amount. Project name, project identification number, project expenditure category, total cumulative obligations. Project overview. 1. Substance abuse treatment services: 113. Abuse: 113. Substance use services: $700,000 to provide substance use treatment and monitor individuals who use drugs in Clark County medical care programs. 114. Other PH services: 114. Other public health services: 1,336. 259. To provide quality health care and promote health equity for people without access to health care in Southern Nevada within a culture of compassionate, caring community. Violence interventions: 111. Intervention: 111. Community violence interventions: 3,014,690. To discover, develop, disseminate, preserve and use knowledge to strengthen the social, economic and environmental well-being of people. Mental health treatment services: 112. Mental health: 112. Mental health services: 3,238,303. To provide mental health and substance abuse services to children, adults and families impacted by COVID-19. Community COVID-19 medical treatment: 16. Treat: 16. Medical expenses including alternative care facilities: 1,500,000. To help outpatients avoid hospitalization and alleviate the burden on the health care system. Community-based testing programs: 12. Test: 12. COVID-19 Testing 142,794 to provide on-site security services for individuals taking the COVID-19 test. County-wide PPE 15, PPE 15 personal protective equipment 16. 725 community and organization personal protection equipment to prevent the spread of COVID-19. Jail mitigation measures 14. Jail 14. Prevention in congregate settings, nursing homes, prisons, jails, dense worksites, schools, child care facilities, etc. 350. 000 The staff and supply required to administer COVID-19 tests and vaccines at the Clark County Detention Center. Clark County Recovery Plan Performance Report 2022 Report page .12. Project name, project identification number, project expenditure category, total cumulative obligations, project overview. 1. Child Haven Mental Health Treatment 110, Youth 112, Mental Health Services 452. 000 Qualified Behavioral Health Services provided, foster care, youth and youth housed in emergency shelter, community-based vaccination program 11, VAC 11, COVID-19 vaccinations 670. 900 The staff and supply of community vaccination sites, vaccine incentive programs, as well as community outreach campaigns that educate and promote the benefits of the COVID-19 vaccine. Workplace safety mitigation 17. Safety 17. Other COVID-19 public health expenses including communications enforcement, isolation, quarantine 338,950. Track and monitor employee testing results, vaccination status and cross-tracing, isolation programs 17. Isolatio 17. Other COVID-19 public health expenses including communications enforcement, isolation, quarantine 15,067. 375 Shelter medical and necessary services to the indigent and visitors who are unable to travel, and residents with limited resources who are required to isolate or quarantine due to an exposure to or positive test for the COVID-19 virus. Services to foster youth or families 213. Foster services 213. Healthy childhood environment services to foster youth or families involved in child welfare system 4,000. 000 to provide shelter and safety to child victims of sex trafficking. Home repairs and maintenance 218. Other housing 218. Housing support, other housing assistance 3,017,160 to provide home repairs and modifications to low income homeowners. Job training, employment support 210. Job training 210. Assistance to unemployed or underemployed workers, e.g. job training, subsidized employment supports or incentives 630. 000 to provide workforce education, training and employment to low-income individuals impacted by COVID-19. Food bank subsidies 21. Food 21. Household assistance food programs 4,287. 701 to provide quality nutritious food and address immediate and long-term food insecurity. Clark County Recovery Plan Performance Report 2022 Report page .13. Project name, project identification number, project expenditure category, total cumulative obligations, project overview. 1. Economic support for impoverished 237. Support 237. Economic impact assistance other 3,480. 000 to provide individuals and families in the community access to healthy and quality food. Rental assistance admin 22. Admin 22. Household assistance, rent, mortgage and utility aid 5,322. 442 to review eligibility of applications to the emergency rental assistance based on documents submitted. Rental assistance subsidies 22. Rent assist 22. Household assistance, rent, mortgage and utility aid 2,320. 000 housing services provided to Clark County community impacted by COVID-19. Small business and workforce development 229. Workforce 229. Loans or grants to mitigate financial hardship 18. 399 Small Business Job Fair and Workforce Development Rental Assistance Data Portal 22. Portal 22. Household Assistance, Rent, Mortgage and Utility Aid 1,814. 560 Design Development Configuration Enhancement and Modification to the County Rental Assistance Portal for residents impacted by COVID-19 to submit electronic applications and supporting documentation for rent and utility assistance. Emergency Shelter Services 216. Shelter 216. Long-Term Housing Security Services for Unhoused Persons 10,204,127 provides non-congregate housing services to indigent individuals and families as a diversion to homelessness to mitigate the spread of COVID-19. Business Mitigation Enforcement 31. Bus 31. Public sector workforce payroll and benefits for public health, public safety or human services workers 16. 758 monitoring business compliance with required COVID-19 mitigation measures broadband gap analysis 521 study 521 broadband other projects 299. 500 a feasibility study for broadband access and broadband gaps within the community revenue replacement 61 Rev 61 provision of government services 367,504,415 government services. Public Safety Payroll Clark County Recovery Plan Performance Report 2022 Report page .14. Project name, project identification number, project expenditure category, total cumulative obligations, project overview. 1. Recovery Plan Administration 71 Plan 71 Administrative expenses 539. 760 administrative costs in connection with the design and implementation of the county recovery plan total $430,282,818. 1. None of the above projects have used evidence-based interventions. Clark County Recovery Plan Performance Report 2022 Report page .15. Performance Report Table 7. Assistance to unemployed or underemployed workers and community violence interventions programming required performance indicators unemployed or underemployed workers and community violence interventions number of workers enrolled in sectoral job training programs number of workers completing sectoral job training programs number of people participating in summer youth employment programs 1.11 community violence interventions 20 to 210 Table 8 household assistance long-term housing security and housing support, job training and employment support services programming required performance indicators household assistance, long-term housing security and housing support number of affordable housing units preserved or developed number of people or households receiving eviction prevention services 2.2 rental assistance admin 2.2 2.2 rental assistance subsidies 2.16 2.18 home repairs and maintenance table 9. Healthy Childhood Environments 2.13 Services to Foster Youth or Families Table 10. Assistance to Small Business 2.29 Small Business Workforce Development 35.6 Rental Assistance Data Portal. Emergency Shelter Services 645.20 Programming Required Performance Indicators Healthy Childhood Environments Number of children served by child care and early learning Number of families served by home visiting. Programming required performance indicators assistance to small businesses number of small businesses served 104 Clark County Recovery Plan Performance Report 2022 Report page .16.
No. I don't know, but I can't verify any of that. All those homeless senior citizens I see down on Water Street, that's just real. They're seniors. I don't think they have another choice. And that's just real. So I've never seen a state do business like Clark County and all of their surveys. Well, I really don't know which set of the population they actually hit, but I know I can keep on doing what I'm doing. That's just sharing that information with you, boo. So in the year 2023, let's just all understand we go